In 2013, at the World Justice Forum at The Hague, I had the privilege of introducing Ruth Bader Ginsburg herself. She was small, warm, feisty, and let me tell you, she could still demonstrate a real man's push-up, literally. The late Justice Ruth Bader Ginsburg is a landmark figure in upholding human rights and gender rights, speaking out clearly, powerfully, courageously, often from a minority position. She had a steadfast commitment to legal reasoning, precedent, and impartial justice by the courts. This is particularly important in the context of some of the WJP's index findings and discussions we have heard in the last 2 days and read in the papers all the time of how the executive branch has become more powerful and less accountable. More than ever before, we need courageous court leaders like Judge Mehmet Tank and Judge Dorota Zablocka, whom we heard on this stage yesterday. Our discussions today are led by another woman trailblazer who, like RBG, as she's known, applies deep intellectual and personal integrity to all that she does. Justice Margaret McKeown is a senior judge of the US Ninth Circuit Court of Appeals. She's very international and has worked with judges and lawyers around the world, from China to Vietnam, Tanzania and Colombia, and more, on women's rights, rule of law, judicial independence, and technology. She has chaired the ABA's 19th Amendment project, which relates to the impact of women's rights to vote, and is an adjunct professor at the Georgetown Law School and jurist in residence at the San Diego Law School. To top it all off, she's an established writer, and her latest book is Citizens' Justice. Margaret, please.
Good morning, and thank you for the introduction. As you all know, justice institutions play a crucial role in protecting fundamental rights against government overreach and also ensuring equal treatment before the law. Today, we are at a flashpoint around the world in the collision between the judiciary, the executive, and the legislative branches of government. The quotation from Justice Ginsburg suggests that they are putting a thumb on the judiciary. But I would say if she were here today and she could see what has evolved since her death, she would say they are putting a fist on the judiciary. So now is the time, of course, to stand up for judicial independence and to ensure that durable protections exist for human rights. So today we're going to highlight the role of the courts as guardrails of justice. And it's fitting that this lecture is dedicated to Justice Ruth Bader Ginsburg. I had the privilege of interviewing her for the 19th Amendment and Equal Rights at Georgetown Law School as her last large public appearance. And it was a privilege. We asked her, well, how many women would be enough on the Supreme Court? And she said 9, without hesitation. So as you know, she's known for her trailblazing work in gender equality and women's rights. She has challenged sex-based discrimination, championed equal access to education and the workplace, in reproductive rights, and she became an icon for women's rights. As you know, she even inspired a meme, the notorious RBG. But I want to say that she is much more than that. She was a scholar, a brilliant mind, a very, very careful writer, and a principled jurist who championed international law. So I think she would be very pleased with our selection today of two wonderful jurists to participate in this special Ruth Bader Ginsburg lecture. From the Nepal Supreme Court, we have Chief Justice Sapana Pradhan Malla. Now, she began as a corporate lawyer and then transitioned into what she would call a cause lawyer, which is really the path that Justice Ginsburg followed. And Justice Pradhan successfully challenged many laws on the basis of gender discrimination. Sounds a lot like Justice Ginsburg. She also served in the Constituent Assembly in Nepal, and then she was appointed to the Supreme Court. On the international level, she's been a member of the UN Committee Against Torture and also implementation of cede, that is the Convention on Elimination of All Discrimination Against Women. From Colombia, we have Justice Natalia Ángel-Cabo. She was the founder and director of a program for equality and social inclusion. And then, like Justice Ginsburg, she was a law professor and a scholar, University of the Andes, and she directed the constitutional program at that university. She then has been in the judiciary a number of times in her life and was a constituent or auxiliary justice at one point, and then in 2022 was appointed to the Colombian Constitutional Court. It was a full circle because she had clerked there for a judge for 4 years. So now I'd like to hear from the justices a number of their thoughts on what's happening globally. So let me start with the individual situations in your countries. You've gone through constitutional transformations. Justice Pradhan, you lived through a conflict era in Nepal, then democratic movements, and the transition to modern constitutional law. Justice Natalia, you lived through armed conflict, then a peace accord, and ultimately the creation of the court on which you serve, the Colombian Constitutional Court. So I'd ask each of you to share with us some reflections on how your countries managed this transition and built the rule of law during a period of change and internal strife. So let me begin with you.
Thank you, Justice McKeown, for a wonderful question. In early 90s, when we shifted from one party to multi-party democracy, there was hope in the air. People believed things would change, but in truth, power was still centralized. Then insurgency started. Struggle of people against poverty, against exclusion, but through the political mobilization. And during that time, we lived our life dying every day. In 2006, guns were silent. The comprehensive peace agreement was signed with big promises. And one promise was transitional justice. You will be heard, you will be honored, justice will be done. That was our commitment for the transitional justice. Constitution was enacted for the first time through the Constituent Assembly. I was one of the members. And now we have started restructuring the state with new constitution in place for republic, federal, secular, and inclusive Nepal. It has incorporated many socioeconomic rights. Each of these constitutional promises have reasons for hope. At the courts, we have become the place where people can turn to when executive and legislature fails to act. Judiciary has been putting its full effort to put rights in place. And our courts have already developed lots of jurisprudence in regards to transitional justice, gender justice, environmental justice, making politics accountable. In fact, last year in Rule of Law Index, Nepal was on top in the highest index in South Asia, and the indicator was independence of judiciary.
Now that is something to celebrate.
Okay.
Well, let me then turn to Colombia, which also went through armed conflict and ultimately a peace process.
So first, I want to thank the organizers of this event for inviting me. I'm really glad to be here, and Margaret, thank you. And second, when you quoted Justice Ginsburg, the quote, that's the one that I said in the Senate when I got appointed, so it has a lot of meaning for me. So I think regarding to your question, of course, the rule of law and fundamental rights in Colombia is still a challenge, but we have made a lot of progress in the past, I think 3 decades. And I think a highlight moment was the enactment of the Constitution of 1991. So before that, the Constitutional Assembly and the enactment of that Constitution, we were living in a really, really tough times of violence. Just to give you an example, 3 years prior to the enactment of the Constitution, 4 presidential candidates were killed. There were 19 car bombs, killing 300 people, journalists, judges were killed every day. But the response, which I think is the highlight of the moment, was not, we did not respond through violence with more violence, but rather with the enactment of a very ambitious constitution that wanted to promote the rule of law, that had a big charter of rights. We incorporated in our constitution not only civil and political rights, but socioeconomic rights and environmental rights. We restricted the amount of powers that the executive had. We promised participation and democracy. So I really think the country has gone through a period of more participation, more democracy, through compromise. And so in general, I would say that we have tried to build legal institutions that work. We are trying to build a more persisting, participatory civil society. And I think there has been a commitment on all authorities. The Constitutional Court was created at the time, and it's not because I serve in that Constitutional Court, but I think has done a very good job in trying to promote rights in the country. Although it's still a challenge, we still live in a very violent country, but progress has been made in the past 3 years dramatically, I believe.
So it's interesting that this Constitutional Court actually grew out of the conflict. And so that's the situation where they are now in Colombia. Of course, we've all talked about, during the past few days, international law and the importance of international law. Justice Ginsburg was what I would call an internationalist. And she was a great advocate for utilizing foreign and international law, somewhat to the criticism of her colleagues. And she said, of course, that we shouldn't just be internally looking, but there is a value to looking at other countries. It doesn't mean that we will apply the law of Nepal or Colombia, but we might actually learn something. So I'd like to ask you, and let me start with you, Justice Sapana, what your view is on looking to international and foreign sources, and whether you get any pushback from your colleagues or members of the bar.
Yes, we applied international law, especially when we were trying to break the centuries of injustice, especially women did not have any right to inherit. So, and we had opportunity because we had a newly established democratic government, which encouraged them to sign almost all the human rights instruments, including cede. And then when we challenged this law as a lawyer, we stepped in not only empty hand, we had this cede, the Convention on the Elimination of All Forms of Discrimination Against Women, with us. Yes, and then what we realized in the process, ratification matters, but treaty jurisprudence matters us more, because our treaty act says, in case of conflict between international law and the prevailing law, international law prevails. So that one sentence became a shield for justice. The principle behind designing the cede gave us strength to give the reason discrimination is not just a language of the law. You have to look into the effect of the law. Equality means correcting injustice and not ignoring them. So this conceptual understanding was turning point for us. As Justice Ginsburg believed in learning from international law, not out of weakness, but out of wisdom. For us, human rights are not foreign, they are human. Yes, there was a pushback. Some of our colleagues said, why are you using Western laws? This is not our culture. Others argued using international law means you are surrendering your sovereignty. Yes, we said we may be surrendering a part of our sovereignty, but for something much greater, for justice, for human rights, for more compassionate Nepal. And they are not Western, they are universal. So when I reflect on this journey, when I think of Justice Ginsburg, I realize we are part of the shared fight, a quiet, steady, but persistent fight for human dignity. And international law was one of our strongest allies in this fight.
So it's interesting because the U.S. Constitution, which has endured for more than 200 years, was drafted long before anyone was talking about human rights, equal rights, women's rights. And so many of the countries represented here today have constitutions that are much newer, and they have enshrined a variety of rights, whether it's women's rights or environmental rights or rights of nature. So there's been really a sea change, I think, in constitutional law. What happened in Colombia?
You would say is new constitutions, and especially in the constitutions in the South, we call it transformative constitutions and sometimes aspirational constitutions, but doesn't mean that they could not be enforced. So our Constitution of 1991 includes directly the use of international law as part of the Constitution. So Article 93 says that is part of the Constitution human rights treaties ratified by Colombia. So it are the same level, they are part of the Constitution, and we are but mandate to have to apply them directly. But we also use international law in other ways. Sometimes when interpreting ambiguous domestic law, we resort to international law in order to clarify or giving a purpose to the law. And we also use a lot of comparative cases more as a persuasive authority, or when there are difficult cases that we don't have the answer. So let me give you some examples. So for example, recently we have had a lot of cases on embryos, and Colombia doesn't have a legislation on embryos. So the way we approach those cases are by reading what is going on in other jurisdictions. Last week we had a very tough case on the internet, and there was a big debate on Colombia and whether our decision will harm the poor. So we look at India that had a similar experience and trying to see if we can just at least foresee what would happen if we, it was about zero rating, is a very tough case in Colombia. So we do use a lot of international law, both because it's mandated in the Constitution with respect to some treaties, and because it also illuminates the way to go forward. Although we also, I said, we also export some cases, and you mentioned it precisely with respect to environmental laws. The fact that we have this new constitution that include environmental rights within the Constitution, third generation rights within the Constitution, made for us kind of easier to address those issues. So for example, I've seen in other jurisdictions that there is struggle whether people have standing or not, like the procedural aspects of those cases. We don't have those barriers. So I think we use international law, we use comparative sources, but I think we also serve as others in addressing issues that for them would be more difficult.
Well, both of you talk about using both foreign and international law really as persuasive and informative. There was a very ill-conceived resolution out of the House of Representatives of the United States saying that judges could not cite foreign or international law. And of course, we are bound by scores of treaties, and we refer to international, and we refer to foreign law, for example, when foreign companies are in the courts of the United States. So I think it's interesting to see what a more open view of this has been. But speaking of that, and we talk about the rights in the Constitution, Justice Sapana, I know, as you mentioned, Nepal's Constitution enshrines a number of fundamental rights, including right to privacy, for example. But you have also spoken about how the legal rights and ideals can also fail to protect people because they come up against barriers like culture, caste, and practical realities. So what are the realities that concern you most today?
Yes, I mean, there's a, when the tension turns into public attack, when judges are maligned or their decision politicalized, it doesn't just affect the judiciary, it chips away at the very foundation of rule of law. So there are different kind of confrontation we are going through because being a federal country, now we have also shared judicial power with the local communities, with the local government. It's a judicial committee. The question is coming up because that judicial committee also holds local executive power, local legislature power, as well as they function as a judiciary. So when people have to choose between approaching a court and the local committee, they often have been hesitating because the reason is competency and trust, and what they expect is a neutrality. We are also going through a little bit tension because now we have a constitutional court in place, but no, we wanted to have a constitutional court, but we compromised for the constitutional bench. And then there is some confrontation between constitutional bench and the Supreme Court because both has a similar power. And then comes to the confrontation between the executive, judiciary, and parliament, which is more difficult, more painful for us in many times because yes, we did. We stepped in certain role of legislature, especially during COVID, because the government failed to pause the limitation periods or introduce the emergency law. So the Supreme Court bridged the gaps to ensure rights to remedy is not suspended. We faced criticism for interfering time and again in a role of executive and parliament, but I still want to reiterate here, we are just doing what a constitution demands to us. It's not a judicial overreach. So the majority of society may be heterosexual, but does not make the rights of minority less valid. Judicial impartiality is tested most when public opinion is loudest, and in such a moment, individual judges matters. Our ethical grounding, our stance matters, our courage matters, because today, to be a judge is not just to decide the case, it is to hold the line between democracy and authoritarianism, between noise and justice, between popularity and the principle. So it's not easy.
No.
Well, you highlight for us that being a judge is not a popularity contest, and none of us entered the profession thinking that it would be, but there also, is some dignity to the office of the judiciary, and that is what we are asking, both of the citizens and, of course, the executive and the legislative. Speaking of access to justice and citizens, Colombia has, I think in its judicial form, something that is quite unusual. It's not quite like the amparo in Mexico, but it's called the tutela, and it allows any citizen to file a claim alleging violation of their fundamental rights. So you can imagine this has resulted in thousands upon thousands of citizens taking advantage of their rights. So, Justice Natalia, how has this mechanism worked, and what's been the impact on the Constitutional Court?
If you ask me what is the most important reform that the Constitution of 1991 made, was definitely the tutela, because we had this big charter of rights, even promising socioeconomic rights, but if you cannot go and try to enforce them, there's no meaning of having a beautiful constitution without possibilities to enforce. So the tutela action is a writ for the protection of fundamental rights. Any citizens can go to any judge in Colombia asking for the protection of fundamental rights. But you sometimes would be shocked, but fundamental rights for us include socioeconomic rights. So this is another discussion. We can go forever with this. So all the tutelas at the end, it is a very flexible mechanism. You don't need to have a lawyer. The judge have to decide within 10 days. And all the tutela actions will go to the Constitutional Court at the end, and the Constitutional Court decides which one of those cases to decide. So all of them will be decided by a judge, but we at the end decide some cases, just so that you have an idea of the magnitude of the tutela action. We receive 80,000 cases a month. 80,000 tutela actions a month, and among them we revise only, the Constitutional Court will just address only around 40 a month. So it's a long process deciding those cases. But for me, the tutela has a very powerful meaning. A justice once called the tutela an instrument of peace. And I do think that tutela is an instrument of peace, because in a violent country such as mine, to see that people go to solve their problems through the judiciary, through the law, it's a gain in itself. And so for me, that is a very, very special mechanism of access to justice. I have numbers, so up to from 1992, when the court started, to today, we have addressed 11,040,000 tutelas. So there's a lot of tutela actions. Some have been enforced, some have not. But there was a recent research which I found interesting, that asking people what do they think about the tutela, and they regarded this instrument as a very positive one, even if they anticipate that perhaps the tutela will not be successful or even not being enforced. And the researcher asked, so why? And said, because at least it made us to feel a sense of hope. Mm-hmm. At least they make us feel that we have an action. We are doing something through institutional means. So I don't think, I'm not condoning that these are not being enforced, but I said this mechanism to be close to people, that the judiciary is close to people. We are not in an ivory tower, but rather down, addressing the most fundamental things, I think is amazing, and I really appreciate that mechanism.
Well, it is a remarkable mechanism, and it really shows a means of citizen access to justice. But at the same time, you still have to deal, and let me follow up, with the executive and the legislative branches, and that tension of particularly the executive, putting his or her fist. So would you just follow up somewhat on what's happening in Colombia on that score?
With the executive and the, yeah, so we are living in sensitive times, and so currently, and we have currently a case where the executive is saying that he has a blockage in Congress, and all that disputes come to the Constitutional Court. So as a matter of fact, today in the afternoon, I cannot be present because we have to decide a case. Fortunately, it's online today, but it's about that. It's exactly about that. The president feeling blocked by the Congress, and we, the judges, have to basically mediate on that front. And I think in Colombia, you're living the same thing that you're living everywhere. every case that we address, it will come under scrutiny, both but one side or the other. So we will not get it right. So one would say you're blocking the executive, or the other would say you are basically promoting authoritarian government. Whatever we said, it will be tough. And we've been, as I think all the countries, under scrutiny, under attack, under labeling, especially about our judgments, with not much debate on the actual judgment, about the legal grounds of the decision. And many expect, and I don't want to take much time, many expect us to decide under pressure and reading the context and not thinking of a decision that must endure these tough times. I think that's the dilemma for us, to have decisions that would be precedents for the future as well, and not only to respond for the immediate times. But that's a tough task.
Well, you talk about precedent, as did Justice Dorota yesterday from Poland, and the importance of precedent. I will note that yesterday, the executive in the United States filed a lawsuit against 14 federal judges. So, and I don't want to comment on the suit, except to say that these themes that you're talking about have really echoed worldwide, and we've heard that again and again at our conference. Let me ask you in Nepal what you've experienced on courts as guardrails between the executive, the parliament, and the courts.
Yes, I did mention we have, of course, there is a separation of power, but also check and balance. But then all the political nature of cases are coming to the court. And when we intervene, we have been accused for entering into the political matters. So what choice we have when case comes to you, when many provision of the Constitution is unclear, you have to interpret it. So there is a lots of time, like even like our former Chief Justice were impeached by the Parliament. That was registered by the executive, and the impeachment was registered, but then they even had to withdraw, because even people came in the street in the favor of independence of judiciary.
So this word political has taken on a new meaning. We used to think of political with a large capital P, and now there are so many cases. Every case is political, because we are seeing this intersection between executive power particularly and judicial power. But taking it to a more micro level, I think there's something interesting in Nepal, and I know you, Justice Sapana, were instrumental in ensuring that marital rape became a crime. But that effort also resulted in threats to you. And as a cause lawyer, you challenged gender discrimination. Could you talk about the barriers you face in trying to break down these barriers, societal barriers?
Yeah, I mean, the fight for equal right to amend the discriminatory law was very hard. It was very hard, but personal cost was real for me. Because when you challenge the discriminatory law, you are not challenging the law, you are challenging the state, and you name it. You are challenging the tradition, you are challenging the culture, you are challenging the custom. You are challenging the religion. Everyone stands against you. And then I want to bring the example of the rape law, because rape law said raping other than your wife. And that one line erased countless of voices of pain, of silence. Many women who came to me for justice, I was helpless because law itself was a barrier. So we challenged the law. Out of many laws, when we challenge the rape law, the court says rape means rape. No matter who is rapist, he cannot get exempted from the punishment. This sentence did not just change the law, it shocked the nation. It shocked me too. What followed were threats to my life, humiliation, and misogynistic attack on me. They said, you are destroying our values. You are attacking sanctity of marriage. You should be shot. It did not matter as much me when they said, women like I should be raped. Then I realized you don't even have to be physically raped. By saying you can emotionally rape, you can humiliate, you can violate me emotionally. So my dignity was attacked not by the law, but by the hate. But I refused to stay silent. I spoke out about the pain, the threats, the fear, and by naming the violence, we disarmed them. When we speak, even with trembling voices, we reminded the world that dignity is non-negotiable. We didn't stop. We kept going until the law changed, and it was never just about me. It was always a collective effort. Even the media became our strongest ally at that time. When many stayed silent, they amplified our truth. This showed how media can play a powerful role in the movement, how it can stand strong as a pillar in the movement. Because if we had stayed silent in the face of fear, fear would have written the law. But when we raise our voices, we reclaim the law and we make justice real.
So the judiciary will not be intimidated. And there is an importance of speaking up and not staying silent. Now we have an example of a very interesting situation in Colombia in terms of global challenges. One of the things we've talked about here is the challenge of the environment. And last year, I think it was your court that recognized environmental displacement could trigger specific state obligations. And that's something that's music to the ears of many people because displacement is a worldwide issue. And yet Colombia has actually tackled that. When you talk about what was the implication of that decision?
So basically, I want to start by saying that each time domestic judges are faced with global problems, increasingly. So it's not only about climate change, but technology and by definitely migration. So everything that we do as domestic judges had an impact on aggregated level. So I think we have to row in the same direction, and this is important. But in Colombia in particular, with respect, so we have a lot of cases concerning migrants, but especially there's a huge case on forced displacement. Colombia has 9 million people in forced displacement due to the armed conflict, one of the highest numbers in the world. And since 2004, we enacted a very big case, is a very well-known case, T025, and we've been following up that case, addressing the issue of people in forced displacement due to the armed conflict. But recently, and I'm very proud to be the rapporteur of the case, we received a case concerning 2 people in forced displacement due to climate change. And it was not recognized as such in our system. When we thought about forced displacement, we always associated with armed conflict. And precisely because we use international law, we said no, forced displacement can have several causes. And we have to address the issue of displacement due to disasters and climate change, which is actually nowadays becoming an increasing issue, an increasing topic, but not very visible. So basically what we said is for the government to enact a public policy addressing the issue. It is just the fact of recognizing that there are people in forced displacement due to climate change is a huge issue in Colombia, because we have 9 million people that we are still trying to address their concerns. So even putting the topic into the agenda is for some people very worrisome. Said we don't have enough money in order to address forced displacement due to armed conflict. Now we are adding another responsibility. But what I think is absolutely important, because the situation exists, not only in our country, exists in all of the countries in the world. And as a matter of fact, now displacement is becoming even more. There are more displaced due to, in some countries, due to climate change and disasters than by armed conflict. So just addressing the issue, putting into the agenda was one of the main aims of this judgment. Definitely we have a lot of challenges of how to enforce this. We started to, the Congress has started to discuss enacting this public policy, but then we have a huge incident in the north part of Colombia with 60,000 people in forced displacement in a month due to armed conflict. So the conversation was shifted. But I think the importance of this case also has a very telling number, 123, which is the emergency number in Colombia, 123 of 2004, at least is calling not only Colombia, but all other parts in the world to address the issue of migration, of displacement due to environmental factors, as we call it. So I think it's an important case.
Well, you talk about the challenges. Each of you has really had amazing challenges that you've faced in your career. You've faced them with dignity, intelligence, and strength. So I know the work is difficult. Where do you find support and inspiration? And as we close our session, what are the bright spots for the future? Let me start with you, Justice Sapana.
Thank you. I mean, support, inspiration, big thing. I think sometimes it comes from the most unexpected, deeply human moments. Bharati, whose husband was brutally murdered, and after years of struggle, when the court gave a life imprisonment, suddenly President granted pardon to the murderer in the name of political impunity. But the court said the president's power to pardon cannot be arbitrary. We reversed the pardon. And next morning, Bharati came to the court, kneeled the door quietly, and it was all in the head news of all the media. The expression of experience of justice by the survivor gave us so much strength at that time. Another moment was when the parliament was dissolved by the court. In the first parliament dissolved case, I was one of the judges. The court said it's unconstitutional. It gave a signal that no one is above the constitution, even the prime minister. And what happened next day was extraordinary. Citizens gathered, but not to protest, but to express the gratitude for maintaining rule of law. So even the prime minister said, whose decision was overturned, he will respect the ruling of the court. So those are the strength for us. The court has been remained as a last hope for the people. And recently, the day you approached me to engage in this conversation, I was about to give a judgment, and where I became in minority in one of the serious gender issue. And then same morning, I was reading about the Ginsburg because when you requested, I wanted to prepare myself. Dissenting does not mean disagreeable. It means having the courage to stand firm in your belief, even if you stand alone. Justice Ginsburg, you are not with us today, but your values, your stand, still giving us strength. You have been inspiring many of us. We have learned how to stay alive in this difficult time to lead the judiciary.
Justice Natalia.
Well, I was also going to quote Justice Ginsburg because even
you
as
can never have too much of
yeah.
Justice Ginsburg, so feel free.
But when I was thinking of another quote, there's a justice in Colombia, was one of the first justices, Ciro Angarita, because I know there's a Colombian here, that when he was appointed, somebody asked, why you want to be a justice? And he said, because I want to recognize law with utopia. And I always love that phrase because I think as a judge, you also have to be a dreamer. You also have to think that what you do will transform and will make a change. I know that somebody said that judges should not be given hope. I think that was said here in the conference. Instead, I do think that we have a mandate to try to do our best to give hope. European judges have this right to hope in some of the jurisprudence. I think what we have to do is to have an active duty of hope, to try to keep the hope alive in these dark times. So where I find inspiration, definitely in the resilience of the Colombian citizens. Those are the ones who give me hope, and I try to bring back hope to others in order to continue pushing for the values that we believe despite adversity.
Thank you. I want to thank Justice Ginsburg for her inspiration. I think you see from the conversation the importance of the global sense of justice, but the importance of impartiality, the importance of international law, and also that the courts around the world are really facing very similar global, political, and other challenges. But in the face of that, we can't overlook how critical it is to look at each country and the importance of their national courts and crafting solutions that really fit within their culture and within their history and their tradition. So I want you to leave here with an active duty of hope and join me in thanking our panelists. Thank you. So now we're going to have a video from the 2024 World Justice Challenge winner. The winner was the Common Cause from the United States. That is a nonprofit organization that does strategic litigation and advocacy to support equality in voting and also in the political process. Thank you, and thank our panelists again.
Redistricting is an important process after the U.S. Census to ensure equal representation by redrawing voting maps so districts of the same type have an equal number of residents in them. Gerrymandering is the manipulation of that process to let politicians choose their voters. That's not democracy, and it's happening everywhere in the U.S. When lawmakers draw voting maps to protect themselves, our voices get silenced. Communities of color are especially targeted. They're split up, packed in, and shut out. That's why we've launched Fair Maps 2030, a national movement to make redistricting transparent, inclusive, and nonpartisan. Thanks to our work, states like California, Michigan, Colorado, New Mexico, and many counties and cities across the country have passed major redistricting reforms. We've helped create independent commissions that give people, not politicians, the power to draw fair maps. And in places like Indiana and New York, we've made real progress at the local level too. Communities across the United States, including people of color who have too often suffered the effects of gerrymandering, are finally gaining representation. But the fight isn't over. We've won through litigation. In fact, we're in court in North Carolina right now. We're helping local leaders build coalitions, pass ballot measures, and hold the line against political insiders. This isn't just about maps, it's about power and fairness. If you care about democracy, join us, because no one should get to rig the rules of our elections. We're honored to have been recognized as a 2024 World Justice Challenge winner in the U.S. Building Trust category.